I have some upcoming surgeries. I will then like to just represent myself.
He is attempting to FOIA communication that I may have had with the court, that I may have had with Mr.
Mr. B, this case is a mess before we even touch the facts. It literally kicks off with, I'll represent myself. Wait, maybe not. Sure, self-representation is your legal right, but judges hate confusion. Every choice from this point impacts the case's rhythm, fairness, and even how the record reads in court. One wrong move, and the entire process slows to a crawl.
Court does call the case of the People versus Larry Lee.
Good afternoon, Your Honor. Mary Tanhouse, Assistant Special Attorney, the People.
Good afternoon, Your Honor. Please, Honorable Court. David Burgess, currently representing Larry Lee.
Your name, sir?
Larry Lee.
All right. Mr. Burgess.
Your Honor, based on representations or communications I received from the court, Your Honor, I filed a motion to withdraw. I also received a letter today from Mr. Lee that the court made me a copy of, indicating he wants to represent himself. So based on the motion I submitted as well as this letter, I'm asking the court to allow me to withdraw as his counsel.
And just so that the record's clear, the court received from Mr. Lee what were, in this court's opinion, I did not read them fully and only.
Here's what you need to understand. Attorney-client communication isn't just private, it's protected by law. If those letters or notes accidentally reveal the defense's strategy, that's like handing the prosecution your playbook. Boom, advantage gone. That's why judges treat privileged material like it's radioactive, handle it wrong, and everything blows up.
A staff member relayed that to me. Were, I would say, privileged communication to the extent the privilege would still exist between Mr. Burgess and Mr. Lee. That is what I, based upon looking at them, what I presumed that they were. That is what I presumed that they were. At that juncture, I informed counsel that I had received them. Because I had viewed them as privileged, I had indicated that I would not let the people see them, but that Mr. Burgess could come by our office and look at what had been received. Shortly thereafter, I received Mr. Burgess' motion to withdraw, and basically that was going to be heard today. Almost immediately thereafter receiving that, I then received in our office mail or however it got to me, a letter from the defendant saying all kinds of different things, but indicating that he did wish to represent himself. That letter that he sent was shared with both sides. Today, I provided a copy to the people and also.
He is making decisions with ease and precision. I'll defend myself. No, I need a lawyer. Actually, forget it, I'll do it solo again. This back and forth kills credibility. In court, consistency is strategy. Judges read indecision as manipulation, and once they think you're playing games, you've already lost control of your own case.
To Mr. Burgess, in this case. All right. Is anything from the people?
Your Honor, just that I've spoken to Mr. Burgess about this matter. I don't have an objection to this motion. That's of course discretion. As far as I've been concerned, we've had communications about this case. He has fought diligently for his client.
All right. Mr. Lee, do you not wish Mr. Burgess to represent you in this case?
That is correct, Your Honor.
All right. And the other thing, you wish to represent yourself, or do you wish the court to sign an order that permits the Office of Manager Assigned Counsel to appoint counsel to represent you?
I would like the latter.
So you want new counsel?
Yes.
So you want at this time and I think it's on page 2 of your communication indicating that you wanted to represent yourself. You want the court to disregard that at this time.
Yes, sir.
You understand that because I'd be appointing new counsel, that's going to require that this matter be adjourned to allow counsel to get up to speed on your case.
Okay. I was unaware of that. Are we talking a 1 month or a 2 week adjournment? Just curious.
Well, it's wherever the court, I've got a very tight schedule, but we will, what day?
August 19th, Your Honor, would be the date.
It would go out approximately a month.
Okay. I have some upcoming surgeries. And so I will then like to just represent myself because I don't, they're very serious surgeries. And so I don't have the time to wait.
I understand that, but when do you think, if you represent yourself, when do you think your examination would be?
I would object to any further delays, and I would like as soon as possible convenient with the court and everyone else. I'm prepared.
You're prepared to what?
I'm prepared to take the first available date for the examination as soon as possible.
Well, I don't know what you're asking me to do, Mr. Lee. Have you reviewed all of your discovery and everything?
As far as I know, the discovery was just 2 pages of the interview with the detective and the victim. And I have reviewed
I'm going to probably believe that there's more than just 2 pages.
Correct, Your Honor.
I just provided copies to Judge. He was at my office in May 8th.
So I would need copies of that.
I mean, Mr. Lee, you're not, would I be correct that you are not prepared to go forth today to preliminary examination yourself? I mean, because you keep going back and forth, you want counsel, then you want that.
So I am prepared to go today. Absolutely.
If you represent yourself, you're prepared to go forth today?
Yes.
This logic is dangerous. Saying, I was there, I don't need the video, is a huge mistake. That's not how evidence works. The footage isn't for you, it's for the judge and jury. It's what proves what really happened, beyond memory or emotion. Skipping video review is like stepping into traffic blindfolded. You might survive, but don't count on it.
So what do you want me to do, Mr. Lee?
I would like to proceed today.
Okay, you understand that it cannot finish today.
Sure. I agree. That's fine.
Would the people have a witness they can start with?
Your Honor, we have a witness we can start with. I will say for the record, I do have concerns that if Mr. Lee is going to be representing himself, he's doing so without having all the discovery. And he, of course, will be held to the same standards as any attorney would be held. So a lot of concerns from the people, but we do have a witness available if that's what the court is inclined to do.
Is that really what you want to do, Mr. Lee?
Yes.
I think I'm going to be honest with you. I think you're just telling me yes, thinking that you're going to get a quicker date. And I am not clear that you're ready to go because you only talked about 2 pieces of paper and counsel's telling me there's a whole lot more in this file.
I understand. I'm willing and ready to go
Do you
today.
have a copy of the discovery?
My attorney hasn't provided me with a copy.
That's not true, Judge. I gave it to him on May 8th. He was at my office. He got it.
Or the 2 pages, yes, that's what I have.
No.
The other stuff I don't have.
Your Honor, for the record, not only is there a full police report, but there's also body camera footage that, again, it might be best to review before.
Have you seen the videos, Mr. Lee?
Well, I was there. I'm assuming they're referring to the body cam footage at.
Well, I don't know. You're making assumptions about what exists, and I don't know. Have you seen the body cam footage, Mr. Lee?
No. No.
Do you still? This way. Would the people be available? It is going to be a mess on the afternoon of the 8th. It's a Friday.
Your Honor, should be available. And I have double. August 8th, Your Honor?
Yes, ma'am.
Yes, Your Honor.
All right. Are you going to be able to? So if I set it on the 8th, sir, and I'm sort of pigeonhole you in on a Friday that I normally wouldn't hold them, but if I do the 8th, are you still wishing to represent yourself, or do you wish an attorney?
I'll represent myself.
Your Honor, the one thing I would like to add, because as I stated, we're ready to proceed today. The victim is here in this visitor meeting this morning. Victim has also been here previously on the exam. I would just ask that we have no further delays on the 8th.
Yeah, if I'm going to be done. If you're saying, Mr. Lee, that you're representing yourself, and I set this on a special date, I'm not going to at that time. If you wish an attorney, then I'll have to deal with that, but I'm not going to let a delay happen. Okay. We're going to go on the 8th.
Yes, Your Honor.
Is that what you want to do?
Yes.
All right. I'm just.
We have a double checking. Safe works.
Pardon?
Safe works for the people.
All right. So that's what I would set. I will advise you at this time, Mr. Lee, you understand that you are charged with the offense of criminal sexual conduct in the 4th degree involving force or coercion. You understand that, sir?
Yes, sir.
And that involves a Stephen Kwanzi. You understand that, sir?
Yes, sir.
You also understand that this is a high court misdemeanor, punishable by up to 2 years incarceration, a $500 fine plus court costs, mandatory HIV and STD counseling, and DNA was taken or should have been taken upon your arrest. You understand that, sir?
Yes, sir.
You understand also that this, under the SORA statute or sex offender statute, is a tier 1 offense and would require registration if the victims are 18 years or older. You understand that, sir?
Yes.
All right. And also other requirements, but I'm presuming that the victim that's the only one that would be applicable in this test, in this case.
Yes, sir.
You understand all of that? You understand that if you proceed to represent yourself, you do so at great peril, and usually doesn't not necessarily work well for people when they represent themselves, but you are constitutionally entitled to represent yourself. You understand that?
Yes, sir.
You understand also that the court is going to make the assumption or presumption that you understand the Michigan court rules and the procedures used in a courtroom. You understand that, sir?
Yes.
You understand that the court would not be there to assist you in any way regarding this case. You understand that, sir? And you understand that you will not be, the court is not going to treat you worse, and not going to treat you better than any attorney or the prosecutor in the case, you will be held to that same standard in conducting this.
Yes.
All right. Understanding all of that, you still wish to proceed representing yourself, sir?
Yes, Your Honor.
All right.
Your Honor, just for clarification, does the defendant want to stand by counsel?
He has not asked for it. I'm not offering it.
I'll take one if it's available. Thank you.
Well, there's going to be a funding issue regarding that. I'll make that determination as to whether or not there be standby counsel, because that can be done elsewise other than this. I will adjourn the preliminary examination in this matter to August 8th, 2025 at 12 noon. That's before me.
Bond violation follow?
Yes, there's that and the bond violation. Yes.
The defense is requesting, you to, examine the information between myself and my attorney, because I am alleging that I did not violate the, bond, the condition of the no contact order of my bond, and, witness tampering, that the prosecution says that I'm guilty of, and the text messages prove,
You're asking me to look at information that would be relevant to the bond hearing?
the text messaging between myself and my attorney, and then the Google AI searches that prove my motive and intent for making the phone call between myself.
Sir, and you're asking me to look at it in reference to the bond violation.
Yes, because I think it should be reinstated.
I will address that on the 8th.
Okay, thank you.
Okay, I'm not making a guarantee I'll look at it or not. I don't know whether or not it's relevant, but I will deal with that on the 8th. At this point, his bond will continue. Thank you. Court does call the case of the People State of Michigan versus Larry Lee.
Good afternoon, Your Honor. Retail Assistant Prosecuting Attorney on behalf of the people.
State your name, please, sir. Mr. Lee, you are here for your preliminary examination. Sir, you have elected to represent yourself. Is that still your wish, sir?
Your Honor, I have not received any of the requested discovery material. I've sent out written requests for the prosecution and my previous attorney, and haven't received anything. So at this point, I'll be needing an attorney to assist, to represent me.
Your Honor, if Mr. Lee can maybe put on the record where he sent that request. I have not been informed of the discovery request from him. My understanding was that Mr. Burgess had a discovery.
You can feel the shift in the room the moment he finally admits, "I want an attorney." That single sentence hits like a reset button. The court loses time, the state burns resources, and the entire schedule flips upside down. Just like that, a simple hearing turns into a procedural nightmare.
I sent it to 200 North Main Street.
But well, there are two issues really involved. You sent out that you wanted a copy of your discovery. Are you indicating that Mr. Burgess did not provide or share with you your discovery?
Correct. I sent out one to the prosecutor and one to Mr. Burgess.
Now, I'm asking a different question. At the point in time that Mr. Burgess is representing you, are you saying that he did not share the discovery information with you?
The only thing that I received was a police report, a 2-page report. That's it. So I didn't receive the file that he was referring to last court hearing. I didn't receive that, no.
All right, let's just cut through the games and trade here. Do you wish to be represented by an attorney?
At this point, yes, I don't have any material
Well, it's not an issue of the material. Do you wish to have an attorney represent you?
Yes.
Okay, under the court rule, he is entitled and can ask for that at any point in time. This is probably going to cause great inconvenience for people, but. And now here's the weird part of the system. While Mr. Drukas, I've appointed as standby counsel, I need you to get to the back office and see what we can get. I don't. All right. Take it back. We'll get that resolved, figure out what the back office wants to do.
When we come back, I just want to make sure I don't forget, there are a few things that you want to address that happened after the last court hearing. So we can do that when we come back.
Something that happened after the last.
Yes, Your Honor.
You were just full of surprises. Fine. I'll deal with it then. Court's going to stand in recess.
All right.
Court does recall the case of the people versus Larry Lee.
Your Honor, right hand assistant State Attorney on that.
Good afternoon, Edward Drukas on behalf of Larry Lee.
All right. Mr. Lee, I've signed the order appointing Mr. Drukas to represent you in this matter so that you're aware. Okay? All right. So in this matter.
Set for a preliminary examination, I'm asking for a brief adjournment. I understand through timing with the court that Monday morning would be available. If we could set it for that time. And
all right.
Opportunity to go over discovery.
Will that work for the people?
Yes, Your Honor. We'll have witnesses present.
All right. So preliminary examination in this matter will be adjourned. Court finding good cause to do so. I will adjourn it to, what is it, the 11th?
Yes.
August 11th, 2025, 9 a.m.
Thank you, Your Honor. When the court's ready, I have a couple of matters to put on the record.
Yes.
Your Honor, first and foremost, after the last hearing we were here for, the victim was present with a support person. As they were leaving the courthouse, they were addressed by someone who identified themselves as the friend of Larry Lee. I believe that person is now sitting in the gallery here today. I've personally warned her, but I would appreciate it if we could repeat that on the record, that the victim is not to be talked to or contacted. I don't have anything indicating that Mr. Lee directed that contact, but I want to make sure everybody's clear so we don't have any further issues regarding contact with the victim of this case.
All right. And which individual are you referring to?
This lady right now.
Emma, you come out this way, please. What's,
Hi.
hello, what's your name? Yeah.
Hello, Your Honor.
What's your name?
I'm Jeanette Thompson.
What did you want to tell me?
Okay, so just to begin here, I'm very respectful. I don't know nothing that happened. When the I believe it's the victim was walking out, he was staring at me and I'm with 3 different women. And since he was staring at me, I said, are you so-and-so? I could identify him. So I think he was just irate because of what he going through. I don't know. But to be honest, I don't know that man. When he was talking, he was using verbal language. He walked back towards me and 3 other women and was kind of upset. And I said, I just want to know if you okay. My bad. I could identify him. That was all it was. I just said, I just want to know you okay. I don't.
Okay, so just stop you right now.
Yes.
So I don't want you to have any contact with the alleged victim in this case whatsoever. It doesn't matter if you are worried about whether or not they're doing okay or anything along those lines. You just not to have any contact, because ultimately, while the people don't have proof that Mr. Lee's involved with that, it could be attributed to him in regard to the behavior, and I don't think you want that to occur. All right? So I don't want any contact whatsoever. I understood.
Yes, sir.
All right. And if I do find out there is, at minimum, I would have you report.
Well, please, can you tell him not to walk up on me
I'm
again?
not going to tell him that.
Okay, because that was
You are, well, hold on. Here's part of a court proceeding.
right.
You are not.
Correct.
So you need to, if it's necessary, you need to get out of his way. There's court security if that
Got it.
becomes an issue for you.
Okay.
Or you can just make the election that you do not need to appear. If you want to see the proceeding that is happening with Mr. Lee, then certainly you may view that on YouTube. So there isn't a reason for you to be here.
Mm.
There is a reason for him to be here.
Got it. Okay.
Understood?
Yes, sir.
All right, thank you. You can have a seat.
Thank you, Edward. One other thing regarding the discovery request that Mr. Lee said he had sent one to our office. I just received the email. It was labeled a FOIA request, so it went to our appeals and FOIA department. It appears it's a mix of, and I'll make sure to share this with Mr. Drukas, but essentially, it appears he is attempting to FOIA communication that I may have had with the court, that I may have had with Mr. Burgess. There's also a grievance / investigation request looking to, it appears, grieve me, potentially more people. I haven't read through the whole thing. Somewhere in there, there's mention that he wants anything related to this case, but the overall idea and heading is FOIAing all communications that have happened in this case, as well as attempting to grieve myself and potentially other people. So I know at this point, Mr. Drukas is appointed. He'll get all the discovery. We've been in communication. I've asked our office to expedite the video discovery to him. I handed him a report that's unredacted, but it is the full police report. So we'll take care of that. But perhaps there should be a conversation Mr. Drukas wants to have with Mr. Lee about the rest of it and anything that may or may not be brought up as part of this case, and that the grievance process is a separate process, which he is entitled to.
Right. If that's what he wishes to do. All right.
Nothing further.
All right. Very good. Thank you, folks.
Thank you.
Everybody have a great weekend.
Thank you.
Bond will continue at this time. We'll see you.